Welcome everyone to our webinar on managing dismissals without costly legal disputes. My name is Roisin. I'm one of our legal solutions consultants here at LegalVision. Today's webinar will be hosted by Saeidul Haque, our senior associate in our employment team. Before we begin, just a couple of quick housekeeping items to go through. So you will receive a recording and a copy of the slides in your email after the webinar. You can submit all of your questions in the Q&A box and we'll answer them towards the end. And we always love feedback, so please complete the feedback survey after the webinar. By viewing this webinar, you are also eligible to receive a complimentary consultation with LegalVision to discuss how we can help your business. To claim, just leave your contact details in the survey that appears when the webinar ends or contact us via our website. So today we'll be discussing fair dismissal, minimizing your risk, what counts as a fair reason for termination, steps to follow a fair and defensible dismissal process, reasonable adjustments and employee rights, key termination risks and how to avoid disputes. We'll also go over the key takeaways towards the end, and that will all be followed by a Q&A at the end. So over to Saeidul now.
Thank you so much, Rasheen. So in terms of employee terminations, this can be quite a high-risk decision for most businesses, and getting it wrong can be quite easy and can lead to costly employment tribunal claims. Not only that, though, we also have to think about the potential reputational damage and the sort of low morale among existing staff as well. Now, with the reputational damage, that's quite important because when it comes to employment tribunal matters, they are public facing. So anyone can sort of attend and view the hearing itself. And often what you'll find is that local newspapers and outlets will attend hearings just to get a little bit of news in terms of ongoing cases. So very much important to bear that in mind, particularly from the 1st of January next year. So the qualifying period for unfair dismissal claims is going to be dropping from 2 years to 6 months. So that's quite a significant change. And the compensation cap that we have in place at the moment will also be removed, meaning that the stakes are getting higher and higher when it comes to employee terminations. So this webinar really is going to focus on fair reasons for dismissal and practical steps we can take as well to minimize the risk to the business of a dispute and also from a reputational damage point of view as well. So what sort of counts as a fair reason for termination? Well, we've got really 5 fair reasons for that. So the first of which is conduct. So conduct-based terminations are essentially those based on disciplinary matters. So, for example, it could be that an employee has maybe failed to follow a reasonable management instruction, or on the lower side, and then maybe on the extreme side, maybe they physically assaulted a member of staff or a member of the public, where there might be potential scope for a gross misconduct dismissal there. So that's conduct-based dismissals. The second of which we've got is capability, and this could be split into essentially 2 different parts. We've got ordinary capability, and then we've got medical capability as well. So for ordinary capability, we're looking at a case where maybe someone is qualified to do the job they're sort of recruited to do, but they're struggling to do it for one reason or another. And it may be that they've not got enough experience in that field, perhaps, or they've not been exposed to certain things. Or it could be based on medical grounds. Maybe they are capable of doing it physically, but maybe mentally there's some sort of issues that are ongoing where we might need to consider adjustments, which I'll explore later on in this session. But if ultimately they're not capable of doing the role, then you could potentially terminate their role for that reason. Thirdly, we've got redundancies. So redundancies, typically speaking, we're looking at a case whereby there's been work that is ceased or diminished or is expected to cease or diminish. So ordinarily what you'll find in those situations, maybe the business is closing a store or just closing altogether, in sad cases that may be. So in those types of situations, you have to follow a fair process before you can sort of go ahead and make those redundancies, but it does count as a fair reason for termination. Fourthly, we've got statutory bans. So this is looking at really illegality for some reason. So it could be, for example, if someone loses the right to live and work in the UK because for anyone to live and sort of work in the UK, they need to have that right. And if they don't, and you continue to employ that person, then it could expose you to claims because you could be breach of the Immigration and Asylum Act, which can have significant financial penalties, but potentially also criminal penalties as well, depending on the circumstances. And the final one we've got then is SOSR or some other substantial reason. And this is basically a bit of a catch-all if we don't fall into maybe one of the other categories that I've described beforehand. So an example of that could be, for example, for instance, we have maybe third-party pressure. So let's say you've run some sort of cleaning company, maybe you've got a client, maybe doesn't like one of your employees and they pressure you to get rid of that employee. That could potentially be a fair reason to terminate that employee's employment. Or it could be that maybe there's another reason. Maybe there's a breakdown in the employment relationship between the employer and the employee. This can often happen, on the back of grievances, maybe when they've raised grievances against senior members of staff who effectively not going to go anywhere. And it could lead to that breakdown in the relationship between those two parties, meaning that it's not possible to move forward with that employment relationship, at least not without significant changes. One thing I would also flag with SOSR is that it can cross over with some areas as well, as I mentioned, with potential grievance there, but also potentially for conduct capability and other reasons as well. So it's always worth bearing that in mind too. So what are the first steps we need to follow to ensure that we have a fair and defensible dismissal procedure? One thing I would say is that the main sort of thing that we need to look at is we always need to do some sort of investigation, a formal hearing, and then the outcome, and then an appeal as well. But it's slightly different depending on which of the fair reasons we proceed with. So, for example, redundancies are going to be very different to the process I'm going to be describing here, but the same process I'm going to describe can be largely applied to most of the other sort of circumstances. So, as I said, the fair process, typically we're looking at an investigation initially to gather all of the facts. We then do a formal hearing, we do an outcome, and then we have an appeal depending on the termination reason as well, and also potentially risk appetite there as well. So what does a fair sort of investigation look like? Well, firstly, it's important that we don't have any sort of predetermined assumptions based on what we've understood the case to be about, even if it is a slam dunk case, so to speak, so an employee physically assaulting another employee. It is still important that we do our investigation. So we speak to the victim or victims, we speak to the alleged perpetrator, we speak to any witnesses, and we gather evidence beyond that as well, which could be CCTV evidence. It could involve speaking to third parties. It could be, depending on the reasons, maybe we have KPIs we can reference as well if it's capability reasons, for instance. So there's lots of little different things that we need to do there. But the important thing is we need to try and gather as much facts as we can about the circumstances before we decide whether or not it's worth escalating to the next step, which is a formal hearing. So the formal hearing itself would encompass largely a similar process to the investigation itself, but it would be used as a tool to build on that. So, in the investigation, you will ask a lot of questions to the employees in question or, other parties as well. But maybe there are some unanswered questions, or maybe we didn't probe enough on certain aspects. So this would give us the opportunity to do that and sort of present some of that information to the employee as well, based on, witness evidence, perhaps, also based on CCTV. In that case I described earlier about the physical assault. If we've got CCTV evidence, we can present that to the employee and say to them, what does this footage show to you? And we can ask direct questions, asking, whether they consider that to be acceptable conduct or not, whether that's, may sound like a silly question, but we have to ask questions like, who is shown in the footage? Do you accept that as you? Just to make sure we're crossing all of the T's there and dotting all of the I's as well before we move beyond that. And then ultimately, it's an opportunity for the employee to explain themselves and explain the thought process behind what happened in that circumstance, whether it's capability, conduct, or otherwise. And then once you've had an opportunity to consider everything, you then need to deliver a written outcome based on that. So one thing I would say there, though, when it comes to this process I've described, it is always very important to follow any sort of internal procedures you have on that. So if you've got an internal disciplinary procedure, always look to follow that. If you've got a capability process, look to follow that as well. It just ensures that we are being consistent and as fair as possible to the employees as well. Because what we don't want is a situation where an employee feels as though we're perhaps biased with the process that we're following, or we're not being as consistent as we were perhaps with a different situation. So consistency is very, very important. Equally, on the bias point as well, if possible, we should try and have different people overseeing different elements for fairness as well. So, for example, we should have one person that will be doing the investigation, so investigating with the employees, so speaking to the witnesses, the parties, gathering the evidence, preparing a bit of an investigation report as well. And then we should pass that information on to this disciplinary officer if we believe it warrants escalation as well for a disciplinary matter. And then finally, we should have another person dealing with any appeals as well. The important point there, though, as I say, is being fair, being consistent, following our own processes as well. And also, we want to be mindful of creating precedent as well, based on sort of past cases and how you've responded and dealt with those as well. Because, as I say, you don't want a situation where we're treating things differently because we leave scope for the employees to try and argue differential treatment, maybe based on protected characteristics or otherwise, well, which I'll explore further with you in this webinar. But going back to the process described then, so we talk about the appeal as well. I mean, that would depend on the termination reason and sort of your risk appetite and also the length of service of that individual as well. But ultimately, the appeal officer would be there to oversee the appeal itself. It'd be very much similar to the disciplinary process itself. If it was a disciplinary process or a grievance for that matter as well. But the idea is, we consider the appeal. The employer should be asked to provide a written appeal, setting out the reasons for that. We then consider that, pass that on to the appeal officer. They should then arrange a meeting with the employee to go through the motion itself. And then the outcome of that could be that we uphold the original decision, which could be the decision to have dismissed that employee or give them a final written warning, for example, or even put them on a performance improvement plan. Or it could be that we overturn the decision and actually maybe issue a lesser sanction. So instead of a final written warning, we might decide actually maybe that was a little bit heavy-handed. We'll go with a first written warning instead in that instance. Or we might decide actually it wasn't even worthy of that and it should never have been a warning being issued in the first place for that. So that could also happen as well. And in some cases, the decision maker might decide actually the process that was followed initially wasn't fair. So we're going to send it back to go through the same process as well again to perhaps reach a different conclusion there. So there's lots of different things we can do with an appeal. Now, ideally, depending on the reason, though, you want to try and sort of build on warnings before any sort of dismissal. So for a first offence, you want to make sure you issue maybe just a verbal warning, and then we build on that to a written warning, to final written warning, and then potentially a dismissal as well. And these warnings, are typically going to sort of sit on the employee's personnel file for various lengths in time, usually ranging from around sort of 6 to 12 months in most cases. Now, in some cases, though, it's not always required to go through that process of escalating the warnings, maybe because it's a redundancy process, so we don't need to issue warnings, or maybe because of the seriousness of the offence itself, that it's not required at all. So, for example, if we've got a situation that I described beforehand, if we've got an employee who has physically assaulted another employee and we uphold that decision, in most cases, in 99% of cases, that's going to be a gross misconduct offence because it's going to shatter the heart of the contract, which is that trust and confidence. How can you really trust someone who's physically assaulted another member of staff? And ultimately, that can have criminal complications for that employee, particularly as well, depending on the circumstances. Equally, as well, as I mentioned, relevance is important as well. If someone's lost the right to live and work in the UK, you don't need to build on warnings because for you to continue to employ them, it might be illegal for you to do that and have added issues for you as well. So, in those situations, you don't need to follow that process. But equally as well, maybe because of length of service of the employee, which again I'll touch on more in the session, you might have the risk appetite to go more, sort of firmly with the outcome as opposed to someone who's been there for a very long time as well. So those things are all worth sort of bearing in mind as well. But before issuing a sanction as well, it's always worth bearing in mind any mitigating factors presented by the employee. Also, their length of service should be considered. Have they got a clean bill of health? So that leads on to, have they had any previous warning for the same thing? So if you've got a situation where you've got an employee that's been with you for 10 years, they've got a clean record and they've maybe committed some sort of act of misconduct, which in most cases maybe final written warning, maybe they've got strong mitigation and also added to the fact they have long service and they've got a clean record, you might go with a written warning instead of a final written warning. So it doesn't mean that you don't issue a sanction at all. That's not what I'm saying. What I'm saying is that you might look at reducing it just because of that mitigating sort of factor. But importantly, we do need to document absolutely everything. So that's from the investigatory side of things to the formal process, and then also to the written outcome and any appeal meeting notes as well. So very important that we document absolutely everything. Most cases, you might have someone that accompanies you to take those notes for you. But, with this day and age, most people nowadays are transcribing things with AI and also just doing virtual meetings to make that easier as well. Either way, as long as you've got an accurate set of meeting minutes, then that would be very important for documentation purposes and evidence as well. In terms of if you're taking sort of physical written notes or even AI notes for that matter, what you should try and do is send a copy of those notes to the employee in question as well, or employees, and then make sure that they sign to confirm, or not even just sign, if you get them to confirm via email that they're happy that they are an accurate reflection of the discussion, that would be brilliant because that just gives us more evidence we can rely upon if there is any sort of issues later down the line. So do bear that in mind. And with the sort of transcription tool, just bear in mind also you need to be compliant with GDPR as well. So do make sure we get consent or make sure we've got it written down in our privacy policies as well. And then finally, just on that point as well, we do in most cases need to issue some sort of outcome letter with written reasons for our decision. So whether that's, us dismissing someone, we give them written reasons, maybe because it's a conduct related reason, we might say it's because we upheld the decision on the basis that you physically assaulted X employee on X day at X time. This is evidence and supported by these reasons. So give a breakdown of our reasons as well to uphold that decision ultimately as well. And then we should provide the right of appeal where relevant as well. So, in cases of redundancy, you might confirm, they've all been made redundant. You confirm the final pay and things like that as well, but also potentially give them the right of appeal as well. And as I mentioned before, if we can, and if we've got the administrative resources, let's try and have different people dealing with different aspects of it. Of course, with smaller businesses, that's not always possible. So, if you can, great. If you can't, it's not the end of the world. What we should also bear in mind when it comes to specifically disciplinary matters and grievances as well is that there is a bit of a statutory code of practice put in place by ACAS, which is basically a government body that oversees any sort of employment dispute. So they've got a really handy guide on how you should ideally follow a disciplinary grievance process. And the reason why it's so important as well is because if we don't follow sort of guidance given to us by ACAS, then a tribunal, if there was a dispute, would be able to adjust any award made in those cases by up to as much as 25% for an unreasonable failure to comply with any provision of that code. So it could be that maybe you've not done an investigation when in most cases you should have done, or maybe you've not done any disciplinary and you've just dismissed an employee without any sort of process at all. So ultimately, if the tribunal feels that you've made an error in some way or just unreasonably failed to follow it at all, then they can increase that award by up to 25%. So that is significant uplift as well. If an employee's been given a significant amount of compensation as well. Conversely, though, if they feel as though an employee has unreasonably failed to follow the guidance set out in the code, they can also reduce an award by up to as much as 25% as well. So an example of that could be maybe that an employee has raised a grievance, they've declined, attending meetings with us to discuss their grievance, the scope of it, or maybe they've refused to appeal the decision, or maybe they've acted in a manner that is unbecoming of an ordinary and reasonable employer as well. That's raised the grievance as well. So all of those factors can be taken into account for grievances, similarly for disciplinaries as well. Now, one important thing we really need to consider is when reasonable adjustments might apply, and also employee rights that we need to be mindful of as well. So Reasonable adjustments are an important factor to consider when an employee maybe has a disability and one that is recognized under the Equality Act. So if you believe, someone has a disability, and that's, whether you believe they have it because they've told you it or you reasonably believe they may have a disability, then you have a duty to consider reasonable adjustments before considering a dismissal. Again, depending on the reason for dismissal. Now, a common scenario of that could be capability issues due to long-term sickness absence. So in those instances, we might need to make some adjustments. So that could be a phased return to work. Maybe we adjust the KPIs because they've been off for quite a long time as well. It would be unfair, if an employee's been off because, I don't know, they've had some sort of surgery, they've come back into work and their targets are all the same and they're expected to hit the targets immediately when that actually may not be possible because they've been off for such a long time. Equally, if we've got a situation where we've got performance concerns that may be linked to a disability, when we just say disability as well, just to clarify, we're looking at a long-term condition that could be physical or mental. So that could be ADHD, it could be a physical disability, but ultimately, if it's something that is affecting someone's ability to carry out their job, we should consider reasonable adjustments, and we should consider that with an employee. That may, include seeking advice externally from a GP or an occupational health practitioner as well. But if we believe performance is being inhibited by a disability, then we should try to make those adjustments, which could be some of the things I've described already, which is adjusting KPIs, maybe give them less duties with their agreement, or maybe it could be if they're making grammatical errors, maybe we give them some tools to try and cut those out as much as we can. Ultimately, you're there as a business owner to try and accommodate employees as much as you can, to what is reasonable. When we talk about reasonableness, we're not saying, if you've got a situation where an employee has a disability and they need tens of £1,000s worth of equipment, if you can't afford that, that's fine. You don't have to do that, but you can make certain adjustments that may be reasonable. Maybe, instead of if an employee has issues with grammar, for example, it could be that you just subscribe to a tool that maybe costs £5 or £10 a month that checks grammar. Grammarly, for example, can do that for you. Or maybe these days with the rise of AI, you can say to the employee that you're happy for them to, send things that are non-confidential into AI to do a bit of a spell check or a grammar check before things go out. So there's ways in which we can accommodate those things without having to incur thousands and £1,000s worth of costs as well. And also we have to bear in mind that some sort of conduct issues may be disability related as well. Maybe, an employee may behave in a certain way and be more direct with employees because they've got some sort of mental disability as well. So that does have to be taken into account as mitigation before we take any action. Now, just because someone has a disability or we think they may have a disability doesn't mean that we can't discipline them in any way. It just means we need to consider those adjustments and consider the disability itself before we make a decision. So it might mean that, an employee has been swearing a lot, maybe because they've got, Asperger's or autism or maybe some other type of condition there. But ultimately, they still committed that act. So we might still consider an outcome there, but we might also say to them that we'll consider adjustments to help them moving forwards as well. And occupational health is important as well, just to understand the condition itself, prognosis, and any sort of adjustments we might need to make to help an employee remain in employment, particularly when it comes to capability issues. Now, for pregnancy and maternity, special protections do apply. So pregnant employees are one of the most protected classes of employees, and rightly so as well. And any sort of dismissals during this period can be deemed to be automatically unfair unless it's completely unrelated to pregnancy or maternity. So the important aspect here is that we need to make sure we've got objective reasons for any sort of termination. So if it's performance related, we need to make sure it's not linked to pregnancy or maternity in any way. It's not being impacted by that at all. Other protected characteristics, so under the Equality Act, include things like age, disability, marriage, civil partnership, disability, as I say, as well, sexual orientation. So there's lots of different protected characteristics we need to be mindful of as well. So ultimately, as long as we've got an objective reason that we can point to, so, performance reason, we can point that, that's clearly not linked to someone's sexual orientation or sex, we can clearly show you actually not been performing because you've not hit, if you're in a sales role, you've not hit these KPIs that you meant to hit, you've not reached this level of sales, for instance. So it's quite easy to demonstrate that and quite easily show it's not linked to one of those protected characteristics. But equally, if we've got an employee with over 2 years of service at the moment, then they have protection against ordinary and fair dismissal. So we need to make sure we've go through a fair, reasonable, and robust process before we do elect to terminate their employment. And also, it's worth bearing in mind that this is actually changing from being 2 years to 6 months from the 1st of January 2027. And that will basically apply to any hires from July onwards. So anyone that acquires 6 months of service by the 1st of January and anyone that has 6 months after that will be able to claim unfair dismissal if we don't follow a fair process. So that's quite a significant change, as I say. Also, significantly, there's going to be the removal of the compensation cap here. At the moment, we're looking at a sort of a figure set by the government every year or 1 year's pay, the lower of the two. But with the removal of the compensation cap from next year, it could mean the cost of getting it wrong could be quite substantial as well. It's also worth bearing in mind, going back to discrimination, if an employer has some sort of protected characteristic, they can bring a claim of discrimination from day one, as well as other reasons as well. That may be automatically unfair if you dismiss someone, for example, for whistleblowing. Now, the key termination risks to sort of consider how to sort of avoid that as well and avoid disputes. The first thing is, making sure we follow a fair process, because if we don't, it could see the company very easily at risk of a claim. So it's very important that we do go through that process I mentioned before. So for conduct or capability matter, go through that investigation. We have the hearing, the formal hearing, then we have the outcome, and then we have potentially an appeal as well beyond that as well. So you need to make sure you've got that fair process, but equally you need to have a fair reason for termination as well. So one of the five that I described earlier, whether it's capability conduct, redundancy, or otherwise as well. Because if we don't have a fair reason or we don't follow a fair process, then the risk can increase significantly, especially if you skip steps as well or fail to investigate properly. Now, some of the risks include sort of unfair dismissal, as I mentioned, but also constructive dismissal. So this is where an employee resigns due to a fundamental breach of contract by their employer. So that could be that you breached a fundamental sort of implied duty of trust and confidence by being inconsistent with how you've treated employees, or being quite high-handed with how you dealt with the matter as well, compared to other employees as well. But also we've got the risk of wrongful dismissal. This is typically where we fail to give the proper notice or payment in lieu of notice. So it could be that maybe it warrants a dismissal of an employee for misconduct with notice, but maybe we've dismissed them for gross misconduct without notice. So in those circumstances, if they successfully claim that, then we'd have to pay them the notice pay in that case. Discrimination also is an important one because it doesn't have any sort of service requirement, as I say, and it can be quite costly because compensation in discrimination claims can be uncapped in certain cases. So again, with any of these sort of processes, is very important to document the process we followed, and also making sure we've got that objective reason for dismissal as well, and avoid any decisions based on protected characteristics where we can. Obviously, there are some nuances to that, for example, with medical capability, where someone's not medically able to do the role, but in most cases, we try to avoid decisions based on protected characteristics. And equally, anything that could relate to a claim of automatic unfair dismissal, which applies from day one of employment. So that could be where we've dismissed someone for blowing the whistle for a health and safety complaint, for example, or for some sort of statutory rights or trade union activities as well, which are becoming more and more common these days as well. So it is important that we do bear that in mind. And the timing is also very important, because if someone raises agreements and we immediately terminate them for that, if they put two and two together, they're going to say, obviously, they've been dismissed because they've raised agreements, and that's, them asserting a statutory right, and that would make it automatically unfair for you to dismiss them if that was truly the reason for that. Obviously, these things have to be proven by employees, but you don't want to give them ammunition for that, of course. And as I said beforehand, a failure to follow the ACAS code can lead to an uplift of up to 25%. So always important that we do try and follow that as much as we can as well. In terms of avoiding disputes, the main thing we can do is try and conduct sort of thorough investigations before taking any sort of action. As I mentioned before, speaking to witnesses, gathering evidence. We should allow employees to be accompanied at formal hearings. So that could be a fellow employee or trade union representative, and maybe even others as well, as a reasonable adjustment as well, maybe a family member in those cases. But also importantly, we need to be consistent. We need to try and treat similar cases similarly. We don't want to give employees an argument to say, well, you treated Joe Bloggs differently. Is that because they don't have the protective characteristic of a disability and I do? So you don't want to sort of have those conversations. Try and be as consistent as you can. So rely upon what you followed in the past, if that, of course, was a fair process in the past as well. You also want to keep contemporaneous records of all meetings and decisions as well, factoring in, what process you followed and the objective reasons you had for those decisions as well, because that documentation will be key if there is a dispute, and we really need to rely upon it for an employment tribunal matter as well. We should also try to ensure that decision makers are impartial as much as we can, and they haven't been involved in the investigation where possible. So what I mean by that is going back to what I mentioned beforehand, which is we want to make sure there's different people dealing with different aspects for that fairness. If we can, obviously, smaller businesses may not be able to do that due to a lack of staff. Also, we want to try and give employees adequate time to prepare for hearings. Best practice, I would say, give at least 48 hours for meetings. If you can do more, great, but otherwise in accordance with your policies as well. If an employee tells you they need more time and you believe that actually they could do a bit more time, then do try and give them more time. What we don't want is a situation where we're presenting them with a 100-page investigation report, telling them they've got 24 hours before disciplinary hearing, and then go to the hearing because they won't have adequate time to prepare for that. And that could be a factor they rely upon for a claim of unfair dismissal. So please bear that in mind too. And also provide genuine appeal rights for those to be heard by someone not previously dealt with beforehand, if possible, as well. And if we can, let's try and explore alternatives to dismissal. That's particularly important for those with over 2 years of service. For example, redundancy, we're trying to see if there's alternative roles they can do. For capability, can we maybe redeploy them to a job that they can do? Maybe we can demote them, if they've been promoted to a management role and they're not quite cut out for it, maybe we can send them back to their existing role with their sort of agreement as well. And maybe just other sort of easier things and easy to achieve things like extended support through their managers as well. So the key takeaways for me then are to always try and follow a fair process. And as I say, the fair process will really depend on the reason for the termination. We should also ensure that we have a fair reason for dismissal. So if we do decide to terminate, whether that's SOSR, conduct, capability, or otherwise, we need to make sure we have that fair reason. And we also need to make sure we follow any appropriate policies and are consistent with how we've handled similar cases previously as well. Where applicable, we need to make sure we follow the ACAS code of practice on disciplinaries and grievances to avoid that potential tribunal uplift if there is that escalation. We should document absolutely everything, so meeting minutes, letters, so on and so forth, and make sure we can rely upon those for future matters as well. And consider reasonable adjustments, again, where possible for sort of disabled employees and those with long-term health conditions. Where we do decide to terminate or where we issue a sanction of some sort, we should provide clear written reasons as well and offer the right of appeal if it is appropriate, and always best to seek legal advice before proceeding with any course of termination, I would say. So that really concludes the main part of the webinar. So I'll just hand over to Rasheen to go through a couple of points before I go to a Q&A.
Brilliant. Thanks, Saeidul. So you may find our publication useful. It's on 2026 key UK employment law changes. You can find that in the resources tab on our website, or of course you can scan the QR code just there. You may also be interested in our upcoming event. So our next webinar is on new unfair dismissal requirements, what employers must do to comply. So that's on Thursday, the 14th of May at 11 a.m. You can register via the link below. So we're going to answer your questions very shortly. While you submit them, we'll just take a minute to tell you about LegalVision's membership. So by becoming a LegalVision member, your business gets unlimited access to our full team of 100 plus specialist lawyers for all of your business as usual legal needs. Our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and unlimited domestic trademark applications, and much more. As a LegalVision member, you essentially won't worry about the cost of lawyers again. Think of it like having your own in-house legal counsel. We'll take care of all of the business as usual legal work, so you can focus on running your business. We also offer a dedicated service for in-house teams and general counsel to manage your high volume business as usual legal tasks. Our lawyers invest upfront in understanding what's important to your business and work as an extension of your in-house legal function. So to learn more about how the membership or the desk extension can help you, you can request a free consultation when the survey appears at the end of the webinar. So we're going to hand back over to Saeidul in a moment to answer your questions. While we do that, you'll see a poll question pop up. So we'd really appreciate if you could answer that. So over to you, Saeidul.
Thank you so much, Rasheen. So we've had a number of questions come in from some of the audience. So I'll try and work through as many of them as I can. But if I can't get through them all, then do please go ahead and claim that free consultation mentioned by my colleague. So one of the first questions we've got then, you talk about the right of appeal where appropriate. When would an appeal not be appropriate? So we've got a couple of questions on that. So it's a really good question. So an appeal is appropriate in most cases of dismissal. You know, if we've got a dismissal for capability or conduct, or even a redundancy, in most cases it's going to be suitable for you to go ahead and give that right of appeal to employees. But it also depends on other factors as well. For example, if the reason for dismissing the employee is because of a statutory ban matter, so illegality. So if they've lost their right to live and work in the UK, then holding an appeal is going to be futile, because if they don't have the right to live and work in the UK, an appeal is not going to change the outcome of that. So in those cases, you might decide not to go ahead with the right of appeal. But it is important that we don't act too hastily, of course, as well, even in cases like that. So if it is a case that the employee may actually still obtain the right of appeal, maybe they've appealed a decision with the Home Office or something like that, maybe in those circumstances, it may still be suitable for you to allow the right of appeal. But if it's a case of, this person's lost the right to live and work in the UK, they're going to be deported and they're not going to be able to live in the UK at all, then in that case, of course, you can remove that right of appeal. But when it comes to risk appetite, I mentioned earlier, at the moment, you need to have at least 2 years of service to be able to claim unfair dismissal. If you have a situation where someone has under 2 years of service, has no protected characteristic, and we've got pretty clear reasons, objective reasons for that matter as well, to dismiss someone, you might decide not to give them the right of appeal, because you might consider actually they can't bring a claim for unfair dismissal. The only claims they can bring would be things like discrimination or contractual claims. But as long as I pay them everything they contractually owed, and as long as I can show it's not linked to a protected characteristic, then there's no reason why we can't go ahead and dismiss that person and don't give them a right of appeal as well. What we don't want, though, is if you've got a similar situation like that, where you've had, maybe two employees, both under 2 years service, both with no protected character. Maybe one's got protected characteristics and one doesn't. Maybe one that doesn't have the protected characteristic, they're the ones that have been sort of been given the right of appeal, but the one that has the protected characteristic hasn't been given the right of appeal. So even though they're both in the 2 years, the person that has a protected characteristic could potentially still pursue that claim or argue that that was the reason for that decision. So it is important that we do consider all of those factors before we make that decision. But yes, of course, depending on your risk appetite, you may decide not to give that person the right of appeal. But also, going back to my earlier point, from the 1st of January, the right of claim unfair dismissal is going to be reduced to those with at least 6 months of service. So more and more people are going to be captured by that sort of change. So meaning most cases you will still need to give the right of appeal. So I hope that answers your question there. So we've then got another question here then. So can you dismiss an employee for any reason, maybe personal, if the employee has less than 2 years of service? It's a great question. So the answer to that is yes, you can, because it goes under SOSR, so the catch-all, which doesn't quite fall under the capability, conduct, redundancy, or illegality. So there's some other substantial reason there. Could be there's been a fundamental breakdown in the relationship between the employee and their peers. Maybe there's been a breakdown in trust and confidence, communication line. Maybe there's been some sort of gross insubordination there as well. So in those instances, even whether they have 2 years of service or not, you could still potentially terminate for those reasons as well. But caveat to that, of course, let's follow that fair process before we make any decision to terminate employment. So I hope that answers your question there too. Got a couple more questions as well. I'll just try and answer those for you. So I've got a question here about who can accompany an employee to formal meetings and what if they cause disruption as well. So that does actually, unfortunately, happen quite a lot. So firstly, who can accompany an employee? Well, short answer to that is either a fellow employee in most cases or a trade union representative, if you do recognize one, of course. Now, What is important to bear in mind is that the representatives are there to support the employees and to clarify any question that you have. They're not really there to try and be disruptive or to interfere with the process itself. And they certainly shouldn't be answering any question on behalf of the employee either. If you have a situation where we've got a representative who is doing these things, who is being disruptive as well, then you can just ask them to stop and explain that if they continue their behavior, that you will adjourn the meeting and, you will need to reconvene with the employer at a later date. If they then continue, you can then stop the meeting, say, we're going to adjourn now, and then reschedule the meeting for another date with that employee and allow them to be accompanied by someone else. And you can just tell them straight up they can't be accompanied by that person any longer because of the reasons you mentioned during that course of that meeting as well. So I do hope that answers your question there too. I've got a question here as well. It says, if you make an offer to demote, does that not expose you to a grievance or a tribunal claim? Also, in the event of conduct, specifically on performance, can you go from a formal warning to dismissal if the grounds are having a significantly detrimental impact on business performance and the team there? So, two-pronged question there. So, if you have an offer to demote, does that not expose you to a grievance or tribunal claim? So, not necessarily, no, depending on the circumstances, because if it is clear, this person is not able to do the role, then as a fair sort of process, you will always try to find an alternative to dismissal. So if the alternative to demotion is dismissal, most employees will take the demotion and accept that. Now, granted, they may still decide to raise a grievance about that, but I would say if the grievance is because they've been demoted, then they should instead appeal the decision for that instead, and you can then deliver the outcome as to why you've made that decision that you have, because frankly the alternative is potentially dismissal. So in most cases, most employees will accept that. Can they bring a tribunal claim? Yes, they can. Tribunal claims can be brought and have been brought by employees very similar circumstances, and this is where the process that we follow is very important, and the documentation behind that is equally as important as well, to try and support the reason that we made that decision, to show that it was within the reasonable band of responses for any reasonable employer as well. And then the second sort of question to follow on from that goes, in the event of conduct specifically around performance, can you go from a formal warning to dismissal if the grounds are having a significant detrimental impact? And the answer to that is yes, you can. So at the end of the day, with performance, most cases it's going to be capability where someone is basically not capable of doing the job. But sometimes it can be conduct, or even better, both, where someone can do something and they know how to do something, but they just don't do it because for whatever reason, maybe they're just not following instruction that we've given to them. So if we're having a situation where we've had to sort of explain this on numerous occasions, but maybe now it's led to quite a significant issue, maybe we've lost a client that's worth a lot of money to the company, we might decide that it's worth moving from a formal warning to dismissal because of the seriousness of the offence and the serious impact it's had on the business as well. So with all those bearing in mind, at the end of the day, yes, we can move from sort of formal warning to a dismissal. So I hope that answers your question there. I can see we've got a few more, but unfortunately, we're running out of time for that. But as I say, that's all we have time for today. Sorry I couldn't answer your questions, but please do remember to fill in the survey at the end of this webinar, and we can sort of assist with those questions by booking in that free legal consultation as well. And also, as I say, while this is a free webinar, we do value your feedback, so please do complete the sort of survey that comes at the end. It only takes 30 seconds or so as well. But otherwise, thank you very much for joining us today.